that the respondents...
Let's start here.
Yeah.
Why are we here?
We are here because we asked for the production. Actually, thank you, my Lord, for returning me to the course. We are here on a habeas corpus application, and you did order that the body be produced, that the second petitioner be produced today by the respondents. He is not in court. He has not been produced. And looking at the replying affidavit of the respondents, they are insisting that they do not have him. Through Corporal Samuel Kitegi.
Senior Counsel.
Yeah.
Today we are here to confirm whether there is compliance with the directions of the court.
Indeed.
So that's where we start.
Okay, I give way to the court.
So,
I yield.
Mr. Maro.
Your Lordship, on behalf of the first to the sixth respondent, I appeared before you yesterday, Your Lordship, and in line, rather in compliance with your directions, pursuant to this order dated the 30th June 2025, I confirm, Your Lordship, that indeed I complied with your direction, order number 1 and 2. I did file a replying affidavit. The same is dated 30th June 2025. To that extent, Your Lordship,
Sworn on?
sworn on 30th June 2025.
Understand?
And served, filed, Your Lordship, I believe it is in the court file. So to that extent, Your Lordship, I want to believe that your order of 30th June 2025 has been partially complied, Your Lordship. What you have not been able to comply, Your Lordship, with is part of order 5, which directed that my client would produce the second petitioner in court today. Your Lordship, in our affidavit dated 30th June 2025, we have given an account of the action taken by the respondents, Your Lordship, in particular, the second respondent. The affidavit is shown on oath, Your Lordship.
So in the affidavit you have done what?
You have been able to give an account of what happened that resulted into the application that is now before you. And Your Lordship, at paragraph 20, my client, Your Lordship, have confirmed that they did not arrest the second petitioner. And so, Your Lordship, the second petitioner is not in the hands of my client, neither is in their custody. It is in the interests of both the petitioners and my clients that the whereabouts of the second petitioner be established. And the investigation is ongoing. Your Lordship, with the permission from me, I have looked at the further affidavit, and at paragraph 8 of that particular affidavit, the CEO of our society, Law Society of Kenya, has indeed confirmed, without troubling evidence, that the second petitioner was picked by the respondent. Your Lordship, The nature of this application is that your
So
lordship
which affidavit have you looked at?
is an affidavit that has been served this morning.
Give it a name.
It is a supplementary affidavit sold by Florence Muturi, dated today. Paragraph 8, your lordship. The one Florence Muturi indicates that the second petitioner was picked by my client, your lordship. There is no evidence that have been produced in this court, your lordship, that indeed the second petitioner was picked by my client. Your lordship, the nature of this application is that he who alleges must prove. Section 107 of the Evidence Act, your lordship, demands that counsels appearing for the first and second petitioner do convince this court that indeed they saw, or rather they witnessed, and confirmed that my clients, in particular the second respondent, did pick the petitioner. Short of that, your lordship, this court, I beseech, should give my clients an opportunity to conclude the investigation so that the second petitioner, your lordship, can actually be arrested, because we want to believe a complaint was made. And when my clients visited the apartment.
Is that on oath or you are speaking from the bar?
Your lordship, that is in my affidavit.
Which paragraph?
This is a paragraph, your lordship, this is at paragraph paragraph 4 of the affidavit, your lordship. There is an OB
Where is that affidavit?
that was registered.
Yes. Yes, relax.
We cannot find. Do attend constitutional we can't have many mistakes.
Yes.
Your Lordship, I was at paragraph 4 of our affidavit, where we confirmed that the second petitioner was under investigation for his involvement in the just concluded demonstration, Your Lordship. Your Lordship, if you look at paragraph 14, Your Lordship, I was at paragraph 4 of our affidavit, where we confirmed that the second petitioner was under investigation for his involvement in the just concluded demonstration, Your Lordship. Your Lordship, if you look at paragraph 14, it's clearly indicated that as at the time my clients visited the apartment of one Ndiang'Ui, Kinyagia, the gentleman was not at his apartment. He had left. The caretaker has also confirmed that the gentleman left in a company of two other unknown ladies, Your Lordship. Their identities was not disclosed. This is at paragraph 14 of my affidavit, Your Lordship. Yes. Yes, Your Lordship. The caretaker, I'm aware, Your Lordship, the caretaker is not present.
No,
But
it's not the caretaker statement, it is the deponent.
Yes, Your Lordship, but
So-
part of this information.
So I record you
Yes.
retain information
Yes.
as it is, rather than attributing it, that it is the caretaker speaking. The caretaker has not it is.
Yes, Your Lordship. This is the statement of Samuel Itegi. Yes.
That information is from the caretaker.
Your Lordship, if part of it, because when my client visited,
That be.
yes, because when my client visited, they did not find the petitioner, the second petitioner. So this information, they retrieved it from the caretaker, Your Lordship. That's why it is here.
That is according to the deponent.
Yes, Your Lordship.
Caretaker said.
Yes, that's the position, Your Lordship.
Caretaker said.
Yes. So, Your Lordship, this necessitated my clients to break into that particular apartment. And, Your Lordship, an inventory, my client, that is the second respondent.
They were present.
Yes, they were present.
Themselves.
Yes.
IG was present.
The DCI, yes, Your Lordship. That is the second respondent. Yes, Your Lordship, I am here for the first to the sixth respondents. Yes.
I'm trying to get the names of those who are present. Because you said your clients were present.
Yes.
So who are these?
Your Lordship, Samuel Itegi was present, who the one was on this affidavit, Your Lordship, among others that have not been identified.
Remember,
Yes.
we are in court
Yes.
with specific people
Yes.
who are named.
To that extent,
Those are the people
Your Lordship, can we retain it at the second respondent?
I should be recording you and not misrecording you. You understand?
Yes.
So when you say your clients were there, number one is IG. Number two is DCI. So they were present.
Yes, Your Lordship.
They were present.
Yes. Retain it as such. And Your Lordship,
Just a minute. IG,
yes.
DCI. Who else?
The officers, Your Lordship,
CS.
Your Lordship, so that we are clear, Your Lordship, these are the officers for the first and second respondents who were present, Your Lordship. Yes, if we put it out as, Your Lordship, it's being recorded, the Inspector General Police in person did not visit, but the officers did visit.
No.
Yes.
It depends on how you want us to report you. So if you say your clients were present, these are your clients.
Yes, and I have narrowed down, Your Lordship, to the second respondent.
So the DCI was present.
Yes, officers of the second respondents. In particular, one is indicated here as Samuel Itegi. Your Lordship, when they broke in, an inventory has already been taken, was taken, Your Lordship, and it is annexure number 1 of my affidavit, and all the items that were collected have also been itemized there. Your Lordship, it is for that reason that we believe the second respondent is still pursuing the second petitioner so that he can answer to some of the concerns that the second respondent raised, Your Lordship. The second petitioner, Your Lordship, I wish to confirm before this honorable court that is not in the custody of either of the respondents. It is now very difficult, Your Lordship, for order number 3 to be complied with. Order number 5, Your Lordship, directing that the second petitioner be produced in court, Your Lordship, because my clients, Your Lordship, and I insist, do not have the second petition. Yes, Your Lordship. Your Lordship, I persuade this court. Your Lordship, there are many. I am just expecting a lot from them. Yes, Your Lordship.
Take that route, you will insist that the next thing you have an exchange. In court, you don't insist, you try to persuade it.
Your Lordship, I stand guided and I want to believe, Your Lordship, I have persuaded this honorable court because we are all here to seek justice and for the interest and benefit.
What you asked to do, you say you do not have it.
Your Lordship, according to the affidavit that I filed yesterday, the investigations are still ongoing. We are still pursuing the petitioner. We can be given more time for us to actually investigate.
Are you looking for him or you are pursuing him?
We are looking.
You have two different things.
Your Lordship, as I indicated, if you look at paragraph 4, a complaint was also made.
Mr. Mara, the difference is taking, now you are in court presenting.
Yes, my client.
So if you want to use his words, it will make a difference. So what are you asking the court to do for now?
The court should give us more time, Your Lordship.
So are you looking for him or you are pursuing him? You know the difference.
Your Lordship, if you are looking for the petition, the second petitioner, let me put it at that. Yes. Your Lordship, that is all, Your Lordship. I requested that at this point, Your Lordship, my clients be given a bit of time.
Enough with the lies.
Yes,
Your
yes, sir.
clients are the abductors. Go tell them to produce the second petitioner in court.
Your Lordship,
Enough with
Your Lordship,
the lies.
that is all.
You must stop the abductions. You must stop extrajudicial killings. We will not come here to listen to your stories. You have abducted someone. His family is crying, and you are here telling us stories. Enough is enough. The extrajudicial killings and disappearances must end now. We must stop this madness. We must stop these evil things you are doing to us. It is not right to abduct someone and not present them to court. And you are here telling us stories about... Let me speak. I will sit down. This is not right. Why should they abduct someone and instead of producing them to court, they come here to start telling us stories about, I don't know, my client did this. Your client what? Then what are we supposed to do? If the people who are supposed to protect us have turned out to be the greatest threat to our security.
Can we proceed?
Yes, my lord. My lord, we have heard the counsel for the respondents. I want to begin by referring you to the working of order number 5. And if you allow me, I'll read it in extenso. That the Inspector General of Police and the Director of Criminal Investigations were named as the first and second respondents, and also the fifth and sixth respondents in their personal capacities, are hereby directed to produce Ndiang'Ui Kinyagia, the second petitioner, in court tomorrow. General of Criminal Investigations do attend court to show cause why Ndiang'Ui Kinyagia, the second petitioner, should not be produced in court or released. It is clear, my lord, that in the absence of Ndiang'Ui Kinyagia being produced in court, the Inspector General of the Police, the first respondent, and the Director of Criminal Investigations, the second respondent, ought to be here before you. Nothing whatsoever has been said about their blatant disobedience of the court order. there has been no compliance. Absolutely. In other words, they are not taking the orders of this court seriously. And that does present a very big problem. Secondly, even if we were to believe them, and we don't, that they do not have him, their business is to investigate and know about the welfare of Kenyans. That's why we pay them, that's why they exist. Ndiang'Ui went missing on the 21st of last month. Today is the 1st. So we are talking of 10 days ago. His family did not just complain to the media. They went to Kenol police station and reported on the 23rd. And that is in the affidavit of Lawrence Muturi. The first affidavit, the supporting affidavit. So from the 23rd to today, there is nothing in the replying affidavit of the respondents of Samuel Itegi to tell us how far they have gone with the investigations and what they have done, if at all, to find Ndiang'Ui Kinyagia. This matter has been very, very public, to the extent that yesterday, my Lord, the DCI, the second respondent, at 4 p.m., long after you had adjourned the hearing and given your orders, therefore we assume that he knew he's supposed to be in court today, decided to appear before the public and deny having Ndiang'Ui Kinyagia in his custody. So he will deny publicly, but he will not come to assist the court to reach a decision. And he will deny publicly in a matter that is sub judice. A very, very disturbing feature of the affidavit of the respondents is to be found in their annexure, their sole annexure to their replying affidavit, which is the inventory of the things taken from Ndiang'Ui Kinyagia's side. It's page 10 and 11. If you look at that, my Lord, and look at our annexure attached to the affidavit, further affidavit of Lawrence Muturi, sworn on the 27th day, yesterday, not yesterday, 27th day of June, which was Monday, where we attached as FM1 the inventory taken of items taken from Ndiang'Ui's house. You will, on the face of it, discover that the annexure SI1 of the replying affidavit of the respondents appears to be a forgery. And which makes the second respondent.
Which one are you referring to?
I would request that my Lord has both of them. The one attached to the respondent's replying affidavit, the first page, and the one attached to our further affidavit, floor FM1. Ours is in color. Theirs is in black and white. Oh, I'm told it's also in black and white. It's my copy that is in color. If you look at those two, my Lord.
Just give me a minute.
Okay. has this one does not have recovered.
Yes, continue.
My Lord, if we start with the date, oh, sorry, may I seek your indulgence to draw your attention that Kipe Mungai has joined our team, and also that Monday opening, I'll be assisted by Abna Mango and Willis in responding. My Lord, if you look at the date, on the one by the respondents, it is indicated 21st with ST on top of 21st.
So that is the one from yourself?
From the respondents. I'm beginning to show the differences. Why we conclude, we say it is a possible forgery. If you look, if you compare with the one by the in support of the petitioner's affidavit, the date 21st has no ST. It's just 21st June 2025. A further difference, 2025 on the petitioner's supporting affidavit is typed, while the 25...
I thought you go...
Yeah.
over the respondents.
Okay, let me do that.
And when you are done, you now come to the petition.
I'll do that.
So that there is...
It's methodical.
Yes.
Okay.
So
the differences, we have noticed several
the date
differences.
has 21st.
I had ST to
yes.
signify 21st.
Yes.
And the date 2025, 20 is typed,
yes.
25
yes.
is written by hand.
Yes.
Then it has 6 items. It ends at number 6.
Yes.
Then it has the name of a witness, Jane Ndiang'Ui. Then when you come to the respondents, not to the respondents, to the applicant, to the petitioners. I'm done with the respondents.
So the differences are?
The differences are
Date
21st does not have an ST, and the year.
6. I'm done.
And,
I've marked 21st ST.
yes, and then the 2025 is typed wholly. It's not written by hand. Unlike theirs.
I'm on the respondents.
Oh, we finished with the respondents. I've now started
Yes.
with ours.
So I'm confirming that I got you right.
Yeah, the differences are
21st.
ST and 25 written in pen instead of typing.
Then the items are 6.
Are 6.
The witness, Jane
Ndiang'Ui.
Mm-hmm.
Yes.
Okay.
Those are the 3 notable things in that one. On the one by the petitioner,
Yes.
the date does not have ST, and I've just noticed one more issue, but I'll mention it. Doesn't have ST, and 2025 is wholly typed, not written by hand. And this particular, if you allow me to point a difference I didn't point on the other.
No, let's go.
All of it, yeah.
No, let's go the way you went.
Okay, and then I come back.
Then you now
Come back.
highlight the one you think
Okay.
is outstanding.
Inventory of items above the date taken. Inventory of items taken. It says ceased from inventory of items taken, stroke ceased for the purpose of investigations.
Yes.
Note that one. I'll come back to show a difference somewhere else. Then we go to the items. My Lord, this one has 7 items. That is the petitioners. And there is overwriting on the item numbers. Number 6 is cancelled because number 5 appears to continue up to number 6, so it's cancelled.
Number 7 is cancelled.
Number 6 is cancelled. Number 7,
Item.
the numbering. The numbering. You can see a cancellation on the letter 6, and then an imposed writing on the number below to be 6. A cancellation below number 6, the imposed number 6, and then an imposed number 7. So the petitioners have 7 items and the numbering has been changed.
Yes.
Then we go.
What about witness?
Witness, it is cut, but it appears, the signature appears to be there. This one, yeah. Signature. But there is still The layout appears different at the end from this other one. Where is it? And it has the following words. After number 7, it has recovered from name, House of Kinyagia, Ndiang'Ui. You can see House of Kinyagia, Ndiang'Ui. .096 is not there. Sergeant 096. A feature that is also will distinguish the petitioners is the item number 7, which talks of okay. Item number 7, the difference is actually not the writings, is that on our annexure, the petitioner's annexure, item number 7 is on page 1. There is no page 2 of the inventory. It's whilst...
So the petitioner's documents have only one page?
Only one page.
No? One page.
Whereas the respondents is 2 pages. You'll see that number 7 is on page 2. Ours, it's all on 1 page. You will also notice. Oh, this is the time. Yeah. But you see the one with the coat is black and white. Yeah, we can leave it for now. So what we are saying... So we do not have the signature of Oya. Yes. This one is not anywhere here. Yes, yes, it's not there. And this is ceased. This is sin. Where did I see sin? No. No, the word sin. This is sin. It also has the word sin. This one. No. Yes. This.
Yes.
The last distinction between the two I would like to point out now is on the respondents. On the respondents, if you look at below the Directorate of Criminal Investigations, it is inventory of items taken, seized from the suspect, seen for the purpose of investigation. Now, if you look at the petitioners,
the words inventory appear at the top.
The word that is not similar in both is the word sin, as in sin of crime. Whereas the respondents, one in that heading has the word sin, and these are typed. The word sin does not appear on the copy of the supporting affidavit of the petitioners. Yeah. I'm not a document examiner, but even the writings appear different. So with respect, we suspect that the exhibits annexed to the replying affidavit of the respondent, Kopro Itegi, are a forgery. And following the press conference of the second respondent, with respect, we see him as a person of interest, and we would be happy to cross-examine him if he was in court. I do not think, my Lord, that you'll be able to get to the bottom of this matter without his personal appearance and without the appearance of the Inspector General. Apart from the need to comply with court orders, law enforcers cannot become lawbreakers and fail to comply with court orders. As I yield to my colleagues, my Lord, you will note from the documents, and I've already stated it, that Ndiang'Ui, Kinyagia, has been missing for the last 10 days.
Yes.
I just want to say, my Lord, with respect, that it appears, because this is not the first case, that detention without trial is being returned. Kenyans refer to the Kanu era when it happened as the dark days. Those dark days, my Lord, at least the state used to acknowledge it's holding somebody by whipping out a detention order. The detention today, extrajudicial detention, is accompanied by a denial. I'm just wondering aloud, why would we have documents that are so dissimilar that are most probably a forgery? We need an explanation from the two individuals, Inspector General and the Director of Investigations. And I would like to say that any alleged matter said by the caretaker who has not sworn an affidavit and who appears to have made a general statement, not a statement to the deponent. If you look at paragraph 14 of the respondent's affidavit, it says, the said caretaker informed officers that the second petitioner had left the house earlier in company of another man and two unknown ladies. He doesn't say he has been told by her, which he verily believes to be true. It's a marketplace statement. He said to the officers, this is hearsay, should be expunged, unless if the lady herself swears affidavit and avails herself for cross-examination. What if the two others he left with were an advance party to abduct while the others come back and search? Those are things we can never know. I sit just down with one proposition. The coincidence of the house being broken into by the police, which they now admit, and my colleagues will be dealing with the illegalities of that, and his disappearance, and the conduct of the DCI and the police generally in this country in matters relating to abduction leads to the inescapable conclusion that indeed they arrested him and then ransacked his house. I yield to my colleagues.
Lord, very briefly.
Yes, Mr. Chairman.
My Lord, I start from the point that I assume that the respondents recognize that we are in a country operating under the rule of law. And if they accept that fact, then a competent court having made an order, I've never seen orders that are so express and explicit like this one, directing the IG, Mr. Kanja, and the DCI, Mr. Min, to produce Mr. Ndiang'Ui Kinyagia on the 1st of July 2025 at 11 a.m. That's the first part of that order. It is 12:43 at the time I'm speaking. And the two gentlemen have not produced Mr. Ndiang'Ui Kinyagia. This court specifically directed them that if they fail to produce him, in default, they have to attend court to show cause. So we all agree there is no production, but I can see they are not here. I'm only seeing Mr. Marwa. He's not the DCI, he's not the IG. So if we are operating under the rule of law, at the very bare minimum, the two gentlemen should be in court doing the explanations which counsel is purporting to do from the back. Because underlying all this is the liberty and the life of a citizen at stake. We may speak all the English, but there is an individual whose life and liberty is at stake at the end of the day. And that should be the primary concern of all the parties and the law. And in furtherance to that limb, my Lord, Mr. Ndiang'Ui seemed to have only attracted the attention of the respondents.
That is the second petition.
The second petition seemed to have only attracted the attention of the respondents on the 18th of June.
On the 18th.
18th of June 2025, and that is, my Lord, as per the annex 10, the replying affidavit, page 10. Sorry, on the 19th of June. 19th of June, as per the annexure found at page 10 of the replying affidavit, is a letter signed by one Zachary Kariuki, the DCI Operation Support Unit. And that letter, my Lord, it is the first time that the question of liberty of the second petitioner is being discussed. Before that day,
referring to
Page 10 of the replying affidavit of the respondents.
that item is
It's a letter dated 20th of June.
that item is
It's a letter dated 20th of June.
that item is
It's a letter dated 20th of June.
that item is
It's a letter dated 20th of June. There its residence, as confirmed, walks like a duck. It can only be a duck. And in their replying affidavit, they are speaking to recoveries of items in his house, confirming presence in the scene. They are not speaking to investigating or finding this man, the substance of this Habius application. If they were really minded to protect the fundamental rights of the second petitioner, and if they didn't know where he is, the report to court today will have been the number of witnesses they've questioned, the track and trace they are deployed, the CCTVs they have seen around the scene, to explain the whereabouts of a Kenyan who they will have said they in their custody. But to the extent they are not talking about that, they're only talking about the items they've recovered and a purported expose. We can only conclude they have it. And those are the questions. If the orders of this court issued yesterday were complied with, we will be asking the two gentlemen and their subordinates whose names appear on the inventory to have been present at the residence of the second petition.
yes.
So, my Lord, as I conclude, I will pray that this honorable court, to the extent that we have this order still in force, to give dignity and to assert the authority of the judicial process, proceedings with the participation and the presence of the two, Mr. Kanja and Mr. Amin, in person answering this question, and their subordinates who have signed this inventory. Only one agency in this country in the supporting affidavit of Florence Muturi have not been denied the presence of Subarus and the gentlemen in those Subarus in civilian in violation of the law as noted. They make no mention to them. do give justice to the second petitioner and his family.
Your Lordship, if-
You want to add?
Yes, Your Lordship.
Yeah.
There are certain aspects, Your Lordship. I'll be
Which
speaking
ones?
directly to the affidavit.
Which ones?
Yes, Your Lordship.
Which ones?
Your Lordship, I'll be sticking to the contents of a supplementary affidavit, the issue of the arrest warrants, and amendments by manual for the respondents in terms of their interest with the second respondent.
But what has senior counsel done? What has Mr. Willis Otieno done?
Your Lordship, if you would indulge me, perhaps you would find that.
I will, but I want to find out
Yes, Your Lordship.
what you are adding.
Yes, Your Lordship. I'd be speaking to the fact of, Your Lordship, there was an amendment by counsel to the respondent that they are looking for the second petitioner and not investigating. I would wish to point out to this honorable
But that's what he
specific
said.
paragraphs.
But that's what he said.
Yes, Your Lordship. I'll be alluding to their replying affidavit where they indicate that he is a person of interest, as well
Yeah,
as.
they have
our-
said that.
Your Lordship, the amendment was that they are looking for it. Your Lordship, there's a difference between a missing person, Your Lordship, and that person being investigated for having committed a crime.
You
That
know,
was the distinction.
you know, we really have to try and focus on why we are here. You understand the council?
Yes, Your Lordship.
Yes.
Yes.
Today was meant to be a very brief day. So just let me know what you want to add. We have read this affidavit, haven't we?
Yes, Your
We
Lordship.
have read the inventories, haven't we?
Yes, Your Lordship.
Yes. So just add what you want to add instead of making a day very long. Give us your name,
I'm Mr. Abner Mango, Your Lordship.
Mr.
Abner Mango.
So I can have Mr. Mango.
Yes, Mango is fine.
It's easier.
The fruit.
So proceed, Mr. Mango.
Yes, Your Lordship, I'll be very direct and speak to what has not been. Your Lordship, just referring the court to the affidavit in support of the agency. Your Lordship, there is a miscellaneous.
Let's not go there. We read that affidavit. We are here. We are part of that
It has
agency.
not been spoken to. It has not been spoken to, Your Lordship. There is the second annexure. The inventory was the first one, but the second annexure, Your Lordship, to the affidavit in support of the agency, is a miscellaneous application, number E2362 of 2025. This is the affidavit dated 27th of June 2025.
So which affidavit are you looking at?
There is an affidavit in support of agency. Your Lordship, just to give you a brief background.
I have to be there before you
Yes.
give me a brief background.
I'm taking you to 27.
So I'm looking for that document.
Very well.
Don't be in a hurry. You must be looking at a different document.
Yes, Your Lordship.
Which document are you looking at?
Your Lordship,
Give me
there's
the
a
title of that document.
Yes, there's a certificate of agency filed on 27th of June, and there was a further affidavit in support of the certificate of agency.
When here we go by the date the document
Dated
is dated.
27th of June 2025.
When is this agency dated?
27th of June 2025.
Certificate.
Yes, Your Lordship. And that is why I was giving you the background that the initial certificate was filed on 24, and having not been given any directions, another certificate of agency was filed on the 27th of June.
And when was the application seen?
On the 27th of June 2025 is when Your Honorable Lordship gave direction. After the subsequent filing of the second certificate.
24th was which day?
24th was on Tuesday.
It was filed at what time?
24th at 9:34 a.m.
And the receipt up to when?
You see? And Your Lordship, that's what prompted that.
No.
Yes.
See, you seem to be saying
Yes.
we were late in acting on your application.
Yes, Your
So we sit up to what time?
5 p.m.
Do you know when we saw this?
on 27.
And you know it has to be allocated.
Yes.
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 So you know when it was allocated?
On 27. That was after the subsequent certificate.
It can be dated 24th but filed on 26th.
No. Filed on 24th.
I can easily confirm here.
Yes, Your Lordship.
No,
We
but
can confirm.
just check. When was
In
it
fact,
filed?
the first ground of that certificate was that we had filed on 24th. That was our first ground.
Who filed?
Through the firm of VRA.
It was not you. Sindio?
Yes, Your Lordship.
Yeah. So you are told we file. He gave an assistant to upload. Maybe the system was down. That week we had the system was down. Yeah. So you are banning.
Your Lordship, your attention.
Wait. No, but are you able to see at what time did they upload?
27 at 12:14, 30.
And he's saying they uploaded when? That is a certificate of urgency.
Yes.
The initial petition.
On 24th of June, 2025 at 8:19 p.m.
You see? So who sits at night? Don't come here and make an allegation in front of the media. You accuse us as if we don't work. So that was
Your Lordship, my
24.
apologies.
Wait, this is just umefanya mbaya, only that you didn't know. So that is 24th. Then you come here and see. That was the day of the week. No, not 24th.
It's Tuesday.
It's on Tuesday. And then you sit from morning 8:30 up to some time before you.
To two other citizens being arraigned before court in a miscellaneous application based on the same. Your Lordship, then, the said settlement is now supported by paragraph 6 of their response. For you is that on admission of the second and sixth respondent in particular, Your Lordship, and that I'll be drawing to your attention to paragraph 16 and 17 of a supplementary affidavit, that the nature and circumstances surrounding the interests of the second respondent to the second petitioner is clearly alluded to, one, in the miscellaneous application, and two, to his ex account, that is Ndiang'Ui Didi, as well as the press briefing that has been relied upon at paragraph 16 of the said application.
That miscellaneous application number
E2362 of 2025.
before which court?
Before Honorable Dolphina Alego.
Milimani. Milimani Chief Magistrate. Court. So, Your Lordship, the source of the inventory as attached in our application was the very said miscellaneous application, Your Lordship, filed.
Sorry?
The source of our attachment, you saw the distinctions between the two, was in their very own miscellaneous application in 2362 of 2025.
So that application is filed again?
It was filed on 26th of June. It's dated, Your Lordship, it's an undated application. It was not dated. But the affidavit in support is dated 26th of June.
And had the inventory?
Yes, Your Lordship.
Which you have attached?
Which we have attached. Yes. Which Your Lordship now is materially different, as highlighted by Senior Counsel, in terms of the content, different from the one that has been presented in the replying affidavit. Your Lordship, more particularly, if you look as well as to the replying affidavit, Your Lordship, the deponent of the affidavit alludes to officers being sent, Your Lordship, so that the deponent himself does not place himself in sight during the inventory. Your Lordship, I had it. Let me just highlight to you. Your Lordship, I'm now looking at the replying affidavit.
By the respondent?
Yes, by the respondent. Let me just get to the...
He says he's the investigating officer.
No, he does not say, but he alludes to officers being sent.
14. He says, I am the investigating officer. Did he say something?
He says, I am a police officer. One of the investigating officers. But however, Your Lordship, if you look at...
You know, I don't have it.
Yes.
So just assist me. Where do you want me to see?
Yes, Your Lordship, I'm getting it to you right now. Your Lordship, I'm at paragraph 13, yeah? So 11 and 13, I'm at, and at, this is of the second respondent's replying affidavit. So paragraph 10 alludes to a well-planned and coordinated plan to mobilize people, prompting the investigations, Your Lordship. And now, paragraph 10, we are at the second respondent's replying affidavit. Then 11, but more particularly, Your Lordship, paragraph 13 does not place, and that was my point, Your Lordship, the investigating officer on site during that particular search, because it reads, paragraph 13 of the replying affidavit.
We have all read it.
Yes.
Unless you want to read.
Yes, Your Lordship, that on that date, that is 21st of June, officers of the second respondent visited the said apartment, but confirmed that the door was locked from inside, prompting them to track. But more particularly, even if we were to believe, Your Lordship, the inventories produced now by the respondents, the said deponent, that is Sergeant Samuel Iteki, still does not place himself at the site during the taking of the said inventory, Your Lordship. It only alludes to one, Corporal Leonard Sigay and Corporal Ronald Murgo. so that, Your Lordship, the averments then in this replying affidavit is of no personal knowledge of the deponent and is based on a report or an inventory taken that he is not privy to. Your Lordship, as I conclude, the importance of compliance with your order number 5, Your Lordship, based on the press that was next to the link, Your Lordship, is that it is important for the compliance of the said order so that the sentiments captured by the 6th respondent in the press briefing issued yesterday, 30th of June, are those that are well within his personal knowledge, whose veracity, accuracy, and truthfulness can only be asserted, Your Lordship, by way of cross-examination. So that Your Lordship will be urging that this court affirms its orders issued on 30th day of June 2025 and compel for the attendance of the 5th and 6th respondents, Your Lordship, before you to come and ascertain the averments in the press briefing. Your Lordship, I'll say this in passing, that in the said presser, as you'll see on the link, he actually promised to be in court today.
So the link is where?
It's at paragraph 16.
How do I go there?
Later, as you consider.
You want to do that?
Yes, Your
You're
Lordship.
supposed to see that in court, right?
Okay, well,
You don't need to go and do it in...
in chamber. So
You
you,
should have linked us here so that...
very
see
well.
that you have the right.
We will have made
But,
the prior arrangement.
I'm not saying we do that.
Very well. So, Your Lordship, I will finalize with where Senior Counsel, our lead, Mother Karua, started from yesterday, Your Lordship. That it is only this honorable court, Your Lordship, by dint of Article 23(1), that is the guardrail of justice. And Your Lordship, under Article 25D of the Constitution of Kenya, which provides for rights that cannot be limited, non-derogable rights, at D, includes the right to an order of habeas corpus. Your Lordship, we pray that you protect that right. Otherwise, Your Lordship, the citizenry will be left vulnerable and at the mercies of the high and mighty, and we urge this court to act with speed and uphold public confidence, the rule of law, and constitutionalism. Your Lordship, with the permission of Senior Counsel, she requests that Babu Owino makes his maiden presentation before court. He has just one authority that he wishes to highlight.
Thank you, my lord.
Before you go, because I wouldn't want you to be interrupted.
Yes, Your Lordship.
So you want us to insist to use his words. DCI should come here.
Yes, Your Lordship, based on the IG. As per your orders issued on 30th day of June. Order number 5, compliance with order number 5.
Okay, because Mr. Babu will speak last. You will speak last. Mr. Marwa.
Yes, Your Lordship.
Where are these people? My orders were very clear. It's only that you people detour story. The orders were very clear. And if it's not here, they come and show us why it should not be here or this. So where are your clients?
Your Lordship,
That was not explained from the word go.
Your Lordship, permit me to say this. The first and second respondents have before Your Lordship obeyed the orders of this court.
The order was, Mr. Maro, and I don't want to go there. I'm just making an inquiry
Yes, Your Lordship.
because I should have started there. Where are your clients?
Your
That
Lordship,
order was not ambiguous. If it was, probably you seek some
Your Lordship, the
clarification.
order was quite express, and looking at the
So just
time-
answer that question. Where are your clients?
Your Lordship, my clients will attend this court.
No, they were to be here at 11. So they told you they are coming at what time?
Your Lordship, I have no information at what time they are supposed to be here, Your Lordship. Your Lordship, and that is why when I was closing my submissions, I requested for more time, Your Lordship, so that we can conclude.
You didn't
this
ask for more
investigation.
time for them to come. You didn't explain anything about the order. You only said you don't have the subject.
Your Lordship, I actually did when I commenced my submissions. Yes, Your Lordship. And when I was actually going to respond to all the issues that my colleagues have raised, I was actually going now to close on that particular issue. I believe I still have an opportunity to address this court so that they can feed into the gaps that have been raised.
We
by
have come
colleagues.
here first. Very simple. Very simple exercise. Very simple exercise. Mr. Mara and the rest of you. So, Babu, let me give you time. You say as much as you want to say.
My Lord, I would like to start by the seriousness of this matter. That the second respondent, the fifth and the sixth, to show the seriousness that we have, my Lord, have taken even a single statement from the family members of the second petition. My Lord, and they are present as we speak. My Lord, to speak to the writ of habeas corpus in a case of Etrelita de Martinez versus Director General and others, that is in Philippines, and the case which was cited with approval in the case of Masood Salim Hamed and another versus the Director of Public Prosecutions, they defined habeas corpus as habeas corpus generally applies to all cases of illegal confinement or detention by which any person is deprived of his liberty or by which the rightful custody of any person is withheld from the person entitled thereto. In another case, this court said that the ultimate purpose of the writ of habeas corpus is to relieve a person from unlawful restraint. It is devised as a speedy relief from unlawful restraint, my Lord. And therefore, my Lord, this writ of habeas corpus is unlimited under Article 25, whatever the circumstance or whatever the situation. My Lord, as I conclude, the architects of our Constitution sought to address a historical concern. And the survivors of the Nyayo regime, my Lord, endured a very brutal police force that held them incommunicado without trial. And even during that time, my Lord, in the case of Karanja, who was detained without trial and later on murdered, was exhumed and the body was recovered for the families to see. So it means, my Lord, that even during the Nyayo era was better than the era that we have, because at the moment we cannot even get a body that we want. So it is my prayer, my Lord, that this court stamps its authority and help this nation secure justice. Thank you so much, my Lord.
clearly.
I'm not going to go back to service, so don't take me there. Do you have a copy of the petition, Mr. Maro?
Your Lordship, I have a copy of the motion, not the petition.
I'm asking a specific question. Either you have, you don't have.
I don't have.
You don't have.
Yes.
Mr. Mango, do you have a copy of the petition?
Yes, Your Lordship.
Give him. Does he have the attachment? No, no. Does it have? The one you are giving him? Just give him.
I have it.
Contain the same information.
Yes, but this has 7 items. And the one
Correct.
has 6 items.
Yeah.
Yes.
So they contest the one you gave
Yes.
because of one or two some, and you contest the one they have. Yes. That they are signed by the same officers?
Your Lordship, yes, they're signed by the same.
They appear to.
They appear.
Let's use the word they appear to have been signed.
Your Lordship, I've since discovered that indeed, even the one I have has 7 items, has 2 pages.
There is overwriting.
Yes. Not over. Has 7 items.
There is some overwriting.
On this,
I'm just confirming before we leave here so that it doesn't, it's not safe that some document was sneaked.
that is true, Your Lordship.
I'm referring to the document you have just been given by the petitioners.
Yes, I confirm.
Those documents are signed. They clearly show where. And then the one you have given them,
We have.
you also have.
Yes.
That one you have.
Yes.
Okay.
Would the court allow us to clarify something about?
No. You people said what you said. I'm trying to figure out, senior counsel.
It's just that both documents originate from them.
No.
That's what I want
He
to
said
point out.
they appear. I used the word appear because I didn't want to say they came from him.
They filed
They-
it in another court.
That has been said.
Yeah.
It's on record.
Okay, thank you.
Where is the deponent of your affidavit? Where is the officer who saw the affidavit?
As I checked the Lordship, he was in court. Maybe you can give him time to look for it.
When did you check with him last?
Before I got to court, I had a discussion with the officers.
He was here.
Yes.
Is he still here?
I'm not sure, Your Lordship.
Sergeant Samuel Itegi. Samuel Itegi, you are here. Okay. So, your colleague says someone promised that he would be here. Did you hear that? I didn't watch. I don't watch news, so I didn't watch anything that was said.
Your Lordship, I also did not watch news. By the time the DCI was making the purported press statement,
But that was after we issued an order that they should be here.
yes, Your Lordship.
So he was responding to the court order.
I am not sure if he had been served with the order, Your Lordship.
Mr. Marwa, if we go that way, we are going not in a, these things, you are in court and we directed that they be here. So I don't know, but I'm not saying they shouldn't be served. How do you want us to proceed in view of the issue that is before us?
Your Lordship,
And in view of the fact that my order was very clear.
Your Lordship, I wish first, Your Lordship, to say that this is a very difficult matter. I understand somebody is missing, and it is in the interest of both myself and my client, and even the petitioners, that the second petitioner is found.
Yes. And I wanted the second petition,
Yes, Your Lordship.
live or dead.
Yes, Your Lordship.
That's all I want.
Yes, that it is my
They
prayer.
wanted with the body, I said I want him.
That is my prayer, Your Lordship, that he be found.
So we want him.
Yes. So, Your Lordship,
When can we have him? Because someone is keeping him.
Your Lordship, that is a very difficult question posed to me. I cannot confirm on the date and time. I will only be asking for a bit of time so that I can engage my clients, Your Lordship. I cannot speak on their behalf that there is certainty within this period the second petitioner that will find, Your Lordship. You can give us a bit of time.
How much time? I wanted that person, whether he's dead or
Your
alive.
Lordship, as indicated from our affidavit, clearly you've seen the investigations are ongoing.
They have said their story.
Yes.
You have said your story.
Yes.
I'm looking at the two stories.
Yes.
Yes.
Your Lordship, in terms of timing, Your Lordship, we leave it to the discretion of the court. We cannot with certainty say that 3 or 7 days.
We are not interested in any other thing
Yes.
other than the human being.
I am also interested, Your Lordship.
Yes.
Yes, thank you.
So when can we get this human being?
And Your Lordship, that's what I'm saying. It would be very difficult for me to give.
Mr. Maro, tell your clients,
Yes.
and these people, I'm also speaking to these people. Yes. There is no way a Kenyan will get out of his abode and vanish from this world without trace. It's not humanly possible.
That's correct, Your Lordship.
So let's stop doing drama and stick to what the Constitution speaks to.
Yes.
We may not like it. We gave it to ourselves. Those are the words. And the future generation. So when can we have this person? He may be hiding, I don't know. Yes? Because your people, clients are pursuing him.
Yes, Your Lordship.
And he has to live like an animal. So, when can I have this person in court?
Your Lordship, should I be given 7 days to get my plan? And Your Lordship, he can be found even before the lapse of 7 days.
He has been missing since
I believe
21st.
21st.
So today is 10 days. Yeah?
Your Lordship,
All we want
Yes.
is this Kenyan.
Your Lordship, the amount
Where
of
is
time-
he? Nothing more. We are not interested in drama, we are not interested in anything. There is a human being missing. So, where is he? Is he alive or dead? Just that. The responsibility now is on me. They are looking upon this court to get this person alive or dead. And we all have a responsibility.
And Your Lordship, have confirmed, and I wish to reiterate that.
You know, I've read the pleadings, Mr.
Yes.
Mao. Let's not go there.
Yes.
I've read the pleadings.
Yes.
Yes. We take your story with the forcefulness it deserves. We take their story. We balance the two.
Correct, Your Lordship.
I didn't watch the video these people wanted me to watch, so I don't know what was said in that press conference. But let me make my few remarks here. in the calendar. Calendar. So I have heard you. I have heard the arguments, have read the pleadings. One thing emerges clearly, that there was an interest on the second petitioner, and officers from the DCI visited his residence, and they were the last people to be in that residence on 21st of June, the date he disappeared. There are inventories which also appear to be coming from the DCI, which are contradictory. The inventories are said to have been signed by a caretaker. The caretaker did not swear an affidavit to say that she was present, and she witnessed that the second petitioner was not in the residence. And since the DCI officers were the last people to be in that residence, conducted a search, and this person disappeared, and as contradictory as the inventories are, we need an explanation from the DCI where the second 11 a.m. and explain the whereabouts of the second petitioner or produce him in court. This matter will be mentioned on that day at 11 a.m. for further directions and orders. Thank you. I don't need the IG here. Thank you.